Welcome to Real Estate Focus. Our topic is real estate law. With me here today is Barry Gordon. Barry is the president from Gordon, Mong and Arts. Barry has 46 years of real estate experience as an attorney, and he is here today to share some insightful information regarding real estate transactions. Welcome, Barry.
Thank you, Calvin.
Thank you for being here.
My pleasure.
So in a normal real estate transaction, after the buyer has an accepted offer and has performed home inspection, before they sign the purchase and sale, that's when they have to retain an attorney, and therefore that's when you come into the picture.
That's correct.
So the first question is, as a either seller or buyer, why do I need an attorney during the selling and buying real estate transaction process?
The reason an attorney is very helpful in a real estate transaction is, first of all, that you're spending hundreds of thousands of dollars. It's going to be the most important transaction you have in your personal life. We, as real estate attorneys, have seen almost every possible situation that could occur. We want to make certain that the agreement suits your needs and meets all of your expectations.
Great. And in terms of locating or finding an attorney, where should a general consumer should look for in terms of retaining an attorney?
A real estate attorney specializes in purchase and sale agreements and representing lenders. One source of looking for an attorney is the Real Estate Bar Association or the Massachusetts Bar Referral Service. Always look for an attorney who concentrates in real estate, not in litigation. You want the deal to go through, you don't want to have a fight.
Right, so you want to have a smooth and seamless transaction during the process. So it is important. So basically, making sure that as a home buyer or a home seller, to get an experienced real estate attorney. Now, in terms of retaining an attorney, what kind of questions or what should a general consumer look for, with experience in terms of an attorney?
The attorney should understand what your needs are. Also, in Massachusetts, it is required that the attorney and the client have a fee agreement, just similar to the agreement that you have with a real estate broker. The Massachusetts Bar, the Board of Bar Overseers, requires that everything be signed. It doesn't have to be very formal, but it has to be signed. Ask how many closings, real estate transactions, the attorney has been involved in. Are they just out of law school? Have they been practicing for 10 years, 20 years, or in my case, 46 years? I've probably done several thousand transactions and can answer virtually any question that you might have.
Great. Yeah. So basically, that is a great knowledge to have.
Yes.
And so, with that said, I mean, just like a real estate broker, if you will, general consumers, including buyer and seller, should ask, how many transactions have you closed, and so how many years have you been in the business, and what kind of credential that a realtor should have. So some of the questions like that. So that way you know who you're dealing with, and whether that professional has sufficient experience.
Correct.
To help
You want to be safe and have good guidance during the whole process, and know that when you get to the end, you can smoothly move into your house and enjoy the property you just bought.
Yeah. especially their dream homes, I guess. Huh?
Their dream home, the nest.
Yeah, that's right.
You're buying the nest.
Yes. So, what is a purchase and sale agreement?
A purchase and sale agreement is a contract between a buyer and a seller. It outlines the property that you are purchasing or selling, depending on who you are, when you are going to buy or sell the property, how much you're going to pay, and what you expect to find when you buy the house. In some agreements, you buy the washer to the dryer, the dishwasher, and other things such as that. Well, you want to make sure that all the curtains and the blinds stay on the windows. Everything that you expect to be in the house when you move in should be listed on the agreement. The real estate attorney works with the real estate broker to make sure that this is accomplished.
Right. So the purchase and sale is basically the main document throughout the transaction.
That's
And
correct.
it supersedes the offer.
It does.
Yep. And any other documents or agreements that were signed between the buyer and seller beforehand.
Absolutely.
Right. So it is important. It is an important document, if you will. So now, within the purchase and sale, what are the major items that the buyer and the seller should be aware of before signing the purchase and sale?
One of the things you want to make certain is that everything that you found on your inspection are taken care of. If there's a furnace that needs to be fixed, or a roof, or other matters, those things have to be addressed. A very crucial part of the transaction is your mortgage. Most people require a mortgage because they don't have several $100,000 sitting in the bank. So they will go to a lender, and the agreement, the purchase and sale agreement, says when they have to have the mortgage, and if they are not able to get the mortgage, to give notice to the seller that they can't get the financing, so they then get back their deposit. That also allows everybody to know what to expect, and the timeline for each part of the transaction is built into the agreement.
Well, good to know. And in terms of the purchase and sale, there is an agreement that attached to the purchase and sale as well. It's called the rider. So what is the purpose of the rider?
There is a printed form, and certain realtors use the Greater Boston Real Estate Purchase and Sale, and some use I think it's the MAR form.
Mm-hmm. Yeah.
But that is a standard form. There are always certain things that we as attorneys want to make certain are part of the deal. We want to make certain that everybody who we talk to knows what they're getting, that the driveways are all within the lot lines. If you're buying a condo, you want to make sure that there are no special assessments. You want to tailor each transaction to fit you. So it's like getting a very good suit. The suit fits you. It's not just off the rack.
That's good. And now, I know that most of the time, the buyers would have like a buyer's attorney, and also seller would have a seller's attorney. And therefore, what is a lender's attorney does? Would there be any differences between both?
I will explain that, Calvin.
Yeah, sure.
The lender's attorney, which sometimes can be the buyer's attorney, there is no conflict in being the buyer attorney and the lender's attorney, and that often does save money. The lender's attorney searches the title and determines that the property that you're buying has what is called good, clear, and marketable title. Just the same as buying a car, you want to make certain that you own that property. They will have a plot plan done, which determines that the house and the driveway and the garage are sitting on the property and not on your neighbor's property. They will then get a municipal lien certificate from the city of Quincy or wherever the house is to make sure that the taxes are paid and everything gets adjusted accordingly. At the end, at the closing as it's called, all the parties sit down and the lender's attorney makes sure that all the notes and mortgages and all the other documents that the lender requires are there, because you're borrowing several $100,000 from the bank and the bank wants to be protected also.
So when it comes to title, what is the best way for buyers to protect themselves when it comes to title defects or any unknown issues in the title?
In Massachusetts and in most other states that I'm aware of, the best way to protect against title issues is to buy owner's title insurance. In a loan transaction, the bank will require a loan title insurance policy to protect its interest, but that doesn't protect the buyer. The buyer can then rely on a title insurance company that has millions of dollars in reserves to be certain that if something shows up, some great aunt that comes out of the woodwork and says that she owns a piece of the property, the title company will come in and they will resolve the problem.
So in Massachusetts, I mean, what type of titles that the homeowners usually hold?
We have a tradition in eastern Massachusetts, Worcester and East, that we get something called a quitclaim deed. A quitclaim deed means that I, as a seller, give you title to everything that I have. It doesn't necessarily say that it warrants or gives you anything possible, but it gives you everything that I have. That's why it's important to make certain that you have title insurance, and also the bank attorney will certify title to you also. So you have belts and suspenders and make sure that that property is yours. Once the deed gets recorded at the Registry of Deeds, it's your property. Not until then. So always make sure that it gets recorded.
Right, that's the important rule of thumb that I usually tell buyers, that don't do anything to the property yet.
Please don't do anything, Calvin. That would be horrible.
That's right, like, taking down walls or, try to do any renovation works inside the property or outside the property before the deed gets recorded.
Absolutely.
Yeah, because, sometimes it could be run into issues with the title at the last minute, or it get delay of recording or something like that. So
It happens.
Yeah, because people thought that, hey, I exchanged the fundings and I signed the paperwork, and now the house is mine or the property is mine, but that's not the case.
Only when
So,
the deed gets on record, and then only at that point does the seller get its money, and your money is gone solid, it's gone hard.
right. So patience is the virtue, right?
Yes.
Yep.
Yeah.
After closing, especially. Yeah. So.
If somebody tells you that it didn't get the record for a few days,
Oh boy.
you better get all your antenna up because something's wrong.
That's right. That's right. So I mean, it did happen.
It happens.
Yeah.
It
Right.
happens.
And so that's why I always say no surprises.
No.
Right. From A to Z. Yeah,
In my practice, when we get to a closing, all the problems are solved.
Right. That's
So we don't expect any problems. And most of the time, there aren't any.
right. Because in a normal transaction, let alone the most difficult transactions, I mean, there will be like several parties, involved in a transaction. So therefore, if one small glitch could affect the whole transaction. So
The biggest glitch usually is money.
money. That's right. Yeah.
We need to make certain that we have good funds at a closing. Oftentimes, lawyers who are conducting the closings, such as us, want funds wired to them. That way we know immediately upon the time the deed gets recorded, the money can be paid to where it belongs. all the money has to be in our account, not coming tomorrow or not coming a week from now, but at the time of the closing. It is absolutely essential that we have the money.
Right, that's important to know. So in terms of closing wise, now most attorneys would ask the buyers at the closing whether they should get a homestead. So what is a homestead?
A homestead is unique in every state. In Massachusetts, a homestead filed by a husband and wife, a trust, however you hold title, protects the owners against certain types of creditors. So if you happen to be in an automobile accident or you had a business that went south, the equity in the house is protected by filing a homestead with the Registry of Deeds. You get a small amount, by small I mean $125,000 by law. By spending a $35 filing fee, you have $500,000 in protection. You can't buy better insurance for $35.
Right, because especially with a big investment, right?
Yeah.
I mean, so yeah.
And the smaller the mortgage and the more equity you have, the bigger exposure you have.
Right. So now, for an attorney who represent either the buyer, the seller, or the lender, other than working on a purchase and sale, what other duties that an attorney can do for a seller and a buyer?
Well, seller's attorney, if they have one, will prepare the deed. It is the deed that transfers the ownership. In addition to that, sometimes two unrelated people take title to the property. They are the buyers. They intend to get married. They may not intend to get married. It's often very helpful to have a joint ownership agreement between two or more buyers. So in case something happens later on when people aren't very happy, everybody knows exactly what is going to take place.
Right. So make sure everything is in
Everything's in writing. Real estate and writing, we'll say those are the two R's, even though writing begins with a W. But real estate and writing are very, very important to every transaction.
Right. And I've seen, so foreclosure property as well, where the bank says that, you cannot change the purchase and sale. So you either sign the purchase and sale that we drafted, which is the lender in this case,
Correct.
or you don't. So in this case, I mean, what do you do?
Well, even though it says you can't, sometimes you can.
Yeah.
And what you want to make certain of is how much you have exposed in a deposit, and also whether or not the funding, the loan that you are looking for is something that you can obtain. Oftentimes, if you're doing a short sale or other types of slightly unusual transaction, the seller, which is usually the lender, takes a long, long time to agree to the terms of a sale. Sometimes that is not quite in sync with your financing because rates change and you may not qualify. So be very careful to make certain that you have enough money and you'll have it on the right terms so you can buy the property.
So in a normal real estate transaction, let's say if the buyer and the seller would agree on everything and also decide to purchase and sale, and towards the middle of the transaction, they are in the process of getting a loan or financing. Now, certainly the buyers or the seller change their mind of selling the house or buying the property. I mean, what are the
What happens?
Ramification, is that right?
Ramifications.
That's right. That either party have.
Well, if I'm a buyer and I have put down a deposit, maybe $5,000, $10,000, whatever amount, that money is exposed if I don't follow the terms of the agreement. So I decide for whatever reason, I'm walking away from the deal, and I don't have any legitimate reason, I stand to lose all that money. I've had cases where I've represented sellers and the buyer has said, I don't care. I've had them walk away from $50,000 in the deposit.
Wow, it's a big loss.
And they didn't care. If the seller doesn't perform and they do what they're supposed to do, a buyer can often sue for something called specific performance. That means I can force you as the seller to sell me the property. And that threat alone will often make the person sit up and take notice and continue on with the sale.
Yeah. Especially when it comes to money, right?
Yeah, money is very important.
Right. Now, in terms of title-wise, there are 3 different titles. One is called joint tenancy with right of survivorship. So can you explain that?
Sure. If I and you, the two of us own a piece of property,
Yes.
and I want you to have the property when I die, that is joint tenancy with right of survivorship. If I have a tenancy in common with you, my family gets my half, and you become partners with my family. Aren't you a lucky man?
Nice.
The third type of ownership is called a tenancy by the entirety. And it's really a joint tenancy, but it's for a husband and wife, or now a husband and husband, or any spousal relationship that we have in Massachusetts. So what it has, though, is certain additional creditor protections to make sure that the family stays whole. So if you buy a piece of property as joint tenants and then you are married, it's a good idea to change your tenancy from joint tenancy to tenancy by the entirety.
Right, that makes sense. Now, in terms of financing, I had several clients who refinanced before they sold the property. For some reasons, lucky them, I guess, they couldn't find a discharge. So therefore, they still, were able to close. However, the closing attorney had to hold a certain amount of money. I mean, I had one instance where the closing attorney had to hold $30,000 in escrow to close on a piece of property, and within 6 months, I mean, the former sellers still couldn't track down that piece of discharge. Now, a couple of options. I'll have you, talk about it. So in this case, I mean, what should a seller do in this case?
Well, in our firm and many others, we usually can hire somebody who's not inexpensive, maybe costs around $500, who has a great record of finding discharges that we could never find. He won't tell me his secrets, because if he tells me his secrets, I'm not going to pay him anymore. But he will do it, and he's never, ever failed me. And there are a lot of lenders out there that have gone out of business, and they've merged with other companies. Also, there are oftentimes we find what we call defective discharges. And say it was Bank of America that made the loan, but Bank of America of California discharged it. They sound the same, but they're not. So it's important for us to make certain that we get the right discharges and follow up to make sure the title is clear. So that's the protections that a good real estate attorney builds into the transaction.
Now, the professional that you hire, is that a title company, or is it a specialist?
No, it's an attorney who has found a way to get this done. We don't ask.
Okay.
He just does it.
Okay. Don't ask, don't tell, right?
Don't ask, don't tell. But he is amazing, and he's a specialist.
Right, I'm sure, yeah. So now, why a discharge has to be the original document instead of like a photo or negative copy of the document?
Because it's too easy to doctor a discharge. So if I white out some paper and make up a story about what the document is, and we find that's not true, the lender will come in and say, excuse me, I would like my money also, and you'll have a defective title.
I see.
So we don't want to do that. We always want to have the original in our hands. Now, you know now, Calvin, that sometimes we do electronic recordings.
Yes.
But we only do electronic recordings if we have the original in our office. We don't use a photostat.
Right.
That would be illegal, and I frankly would lose my license. So I don't want to do that.
No, I don't think so, right? Not a smart way to go about and do it. Yeah. So now, would electronic recording will become more and more common as the technology trend progresses?
It will. In Massachusetts, we have two types of recording of documents. One is called recorded land and one is called registered land. We can do electronic recordings on recorded land. We can't do it on registered land because the land court, which administers registered land, keeps all original documents. So on recorded land, we're going to see lots and lots more electronic recordings. And I see a day in the future, I don't know when the whole recording process, the whole closing process will be electronic.
Wow, that's awesome.
Yeah.
So now, before the closing, who prepared the HUD and what is a HUD?
Well, today what you and I know as a HUD will be gone in August.
In August of this year.
August of this year.
Wow.
So for the last 30 years or more, we've had a HUD, which is a settlement statement. And basically it says how much the buyer has to bring, how much the seller gets, who gets paid, and in the end, we balance the account. So pretty straightforward. The closing attorney takes all the document numbers from the lender, looks at the purchase and sales agreement, and prepares the settlement statement. And that is the guiding, that is the base document along with all the securitization documents that the lender has to make this all work. But again, none of us know what it's going to look like, but on August 1st of this year, there's going to be a whole new procedure, and it's all going to be a big surprise.
So would it be a
We're all
different
going to
name?
learn.
Or?
Yeah, it's going to be called a closing statement, I believe.
Oh, it's not going to be the HUD anymore.
No, it's going to be 5 pages long.
5 pages long.
Yeah. And it all has to be set in place at, I believe, at least 3 business days before a closing.
In this case, it's not. I mean,
No, now
yeah.
now it could be the morning of the closing.
Yeah, that's right. So that makes things a little bit chaotic, if you will.
Yes.
So
Yeah.
so this is the first time that I hear that as of October of this year is gonna be
August.
all changed.
August
August.
first.
Okay. August of 2015.
Yep.
Yeah. Okay. Great. Well, I want to thank you so much for sharing.
My pleasure.
I hope the insightful information that Barry just shared is going to be helpful to your home search. But with that being said, having a real estate attorney during a real estate transaction is important, including buying or selling a piece of property, because it will protect you legally and also give you peace of mind. Now, an attorney is able to provide legal advice, resolve any legal matters during the transaction process, so that you will be well protected legally after closing. I want to thank you so much for watching and being part of the show.